I've had clients say to me, I thought the police were just chatting with me. I didn't know this was on the record. It wasn't a formal interview. They weren't asking me questions. And now I've made these admissions or something inconsistent. And I go, well, that's a mistake you made. There's no off-the-record comments with police. When you have an interaction with police, nothing on the record. They're always observing. There's always recording. And that's the question for today, which surprises some people. Can police use something you casually said against you? And the answer is definitely yes. There's no question about this. And this happens all the time. And I'm going to give you some examples today. And that's the message. When you're talking to the police, you have to assume everything you said is on the record. They will engage you in casual conversation. For example, let's say they want to ask you about an assault that occurred down the street, and rather than exercising your right to counsel, you just casually say, I was there, but I didn't see anything. Well, now you've placed yourself at the scene of the crime. Thank you very much. Record in the notebook. They've got another witness who may be mistaken identity. Maybe it wasn't you, but you're now at the scene of the crime, and you potentially have hurt yourself when you might be innocent, for example. The same goes for, let's take an impaired driving case. This is a beauty. You have a right to silence, of course. You speak to the lawyer after placed under arrest. The lawyer says to you, don't say anything, don't answer any questions, but maybe you misunderstood the lawyer because they also told you don't even talk because they're going to be noting observations of your slurring, your judgment, your mannerisms, move as little as possible. So you're in the breath room and you're chatting away about going to the cottage and everything, and there's slurring and observations. So nothing's off the record. And this is so important. Police officers, they're trained to engage you in casual conversation. And this will lead to many things. Number one, you could admit something that could convict you unwittingly. Number two, you could say something which is going to be inconsistent with what you might say at your trial a year or two later, because how can, even a most truthful person in the world can never say the same story the same way 100% of the time. So there's always inconsistency. So in Canada, as I've stressed in many videos, which you should watch, you have a right to retain and instruct a lawyer without delay as soon as you're placed under arrest. And that's involving calling a lawyer. The police will call a lawyer, listen to their advice, and that's to shut up. That's to provide the breath samples, of course, and impaired. But in all other cases, it's not to say anything, not to engage in casual conversation. If the police interrogate you or engage in casual conversation, just say, right to silence, 2 words, or not speaking, 2 words. That's how to operate. If you start talking, whether you're an innocent person, whether you're somewhat guilty, whether you're terribly guilty, or somewhere in between, anything you say can and will be used against you. Many innocent people have unwittingly convicted themselves because they've told a version of events, for example, about a bar fight to the police under stress for, say, 2 hours, leave that interview and go, oh God, I forgot to say this, and this, even though they're innocent. They testify 2 years later. They're confronted with those inconsistencies. It's a disaster. And now they're sitting in jail for 3 years for something they didn't do. You don't think this happens in Canada? It happens all the time. We've had many miscarriages of justice. So an innocent person should exercise their right to counsel, speak to a lawyer as well to get that advice. A guilty person should as well. There's no question. Let the state convict you. You don't have to convict yourself if you're guilty. If you're innocent, don't convict yourself. There's no evidence against you. Well, keep it that way. Now, that's the takeaway for today. Everything's on the record with the police. When you're stopped on your car's pulled over, you're a totally innocent person, you pull into a ride program, everything you say is on the record being recorded. After arrest, before arrest, whether it's a homicide, whether it's a speeding ticket, just assume that that's going in a police officer's notebook or being recorded somewhere. Nowadays, many police officers have body cam and audio, so everything's being recorded at the scene. Some counties don't have that yet, but certainly back at the police station, everything's recorded. So just be careful. Don't engage in casual chat with the police. You don't have to answer their questions. You have a right to silence. Exceptions, of course, we've talked about. If you're pulled over in a traffic incident, you have to give your name, your address, your registration, insurance, and whatnot. That's required. But you don't have to answer other questions. Use your judgment in this situation. You have a right to silence. So there you have it. That's a very interesting topic, which a lot of people don't know about in Canada. There's nothing off the record. If the police tell you off the record, they're lying to you, and they're allowed to lie to you. That's another video you should watch. So there you have it. If you've enjoyed this video, please subscribe, and look forward to seeing you back on the channel. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.